Welcome to the Quarles Brady Business Law Training Session, Compliance 2017, Legal Updates and Views from the Front Lines. And now let me introduce you to today's speakers. First, we have Ed Broker. He is a partner in the firm's Business Law Practice Group and a member of the Corporate Venturing team. He balances business results and mitigation of legal risk, concentrating his practice on commercial agreements, corporate and board governance, software licenses, finance and equipment leases, and helping clients in transitional situations, including asset monetization, business expansion, and capitalization. He represents a broad array of national and international clients with concentration in the fields of advanced manufacturing, IT and life sciences, sales and distribution, and hospitality and gaming industry. Next, we have Joe Masterson. He's a partner in the Business Law Group as well and a corporate governance and securities attorney. Joe practices in the areas of corporate governance, securities offerings, and compliance matters. He has extensive experience representing clients in SEC securities registrations and periodic reporting, Sarbanes-Oxley, and Dodd-Frank compliance, fiduciary duties, public and private company stock, asset and business acquisition transactions, and entity governance, structuring, and documentation. We also have a panel of great outside guests with us today to share their experiences. They are Ann Fry, Vice President, General Counsel, Secretary, and Compliance Officer at Vertelis, Inc. in Indianapolis. Next, we have Marcia Gonzalez, Chief Compliance Officer at Indiana University. We also have Andrew Northern, Director of Global Anti-Corruption at Cook Medical Group, Incorporated. And finally, we have Patricia Pettit, Compliance Officer for Latin America for Olympus Corporation of the Americas. Thank you all for being with us here today. Ed and Joe, please take it away.
Thanks, Leo. My name is Ed Broker, as Leo mentioned, and welcome to our Compliance 2017 Updates and Views from the Front Line. Before I begin, I just want to say that our timing is actually perfect. I don't know whether for the corporate counsel in the room, they all got their latest edition of the Corporate Counsel magazine, but the August edition of the Corporate Counsel magazine has an article on riding the whistleblower wave. So looking forward to hearing from Joe Masterson regarding whistleblower updates. Also, our timing is great because I know that we have a couple of healthcare clients in the room and on the panel. And just last month, Sandra Mosier, the acting attorney general for the fraud section and the healthcare fraud section, just announced a joint task force with the healthcare fraud section and the FCPA prosecutors trying to rid out international anti-corruption efforts in the healthcare industry. So our timing is pretty good. So what we're going to do today is we're going to give a very brief update on the anti-corruption statutes, both domestically and then some international stuff. Joe is going to then talk about whistleblower updates, and then finally we're going to try to leave 35 or so minutes to this wonderful panel up here to talk about real live action on what the compliance officers have to face on a day-to-day basis. So with that, let's begin. In the United States, the primary anti-corruption statute is the Foreign Corrupt Practices Act, and it was passed 70 years ago, so actually this is a good year to be talking about the FCPA because it's the 40th anniversary. There are two primary focuses of the FCPA. There's an anti-bribery focus, and then there's an accounting focus for the books and records and internal controls. As it relates to the anti-bribery section, the statute is pretty clear, and it says that it is illegal to corruptly offer or provide money or anything else of value, keywords, and some of those in the United States may have listened to those words in relation to some campaign finance issues that are in the news lately, to officials of foreign governments, foreign political parties, or public international organizations with the intent to obtain or retain business. And all of those words are very critical and are very important buzzwords. Unfortunately, given the paucity of case law, we have to rely on enforcement settlements in order to determine how the Department of Justice and the SEC want to resolve those words. So we'll talk a little bit more about that. With respect to the accounting provisions, there's a book and records provision which require issuers, which are essentially public companies, to maintain accurate books and records and accounts to reflect the issuer's transactions and dispositions of assets. There's also a similar provision called the internal controls provision, which require issuers to devise and maintain reasonable internal accounting controls aimed at preventing and detecting false financial statements and records. So let's look at, Paul, I think we're stuck, frozen here. So who get to enforce the FCPA? And there are two enforcers in the United States. There's the Department of Justice, and the Department of Justice handles the criminal side of the enforcement of the FCPA. They also handle civil enforcement as well, and they cover both the bribery and the accounting provisions. The Securities Exchange Commission gets to enforce on the civil side, and they do also get to cover bribery and accounting provisions. The SEC provisions apply to, or the accounting provisions apply to issuers, which are essentially public companies or foreign issuers that listed with ADRs on an exchange. As I mentioned, because people are afraid to take the Department of Justice to trial, most of the enforcement actions are resolved through settlement. And as I mentioned up on the screen, there's an alphabet soup of what the enforcement settlements are. Commonly, they are NPAs, non-prosecution agreements, and that just means that after the company has disclosed all the relevant facts, the Department of Justice has, through a settlement, agreed not to prosecute the company. Then there are deferred prosecution agreements, DPAs, and those are agreements similar to the non-prosecution, but the company actually agrees as part of the settlement that they admit the facts set forth in the agreement, but as long as they comply with the conditions, then they'll agree essentially to a lesser penalty. Then there are declinations, which means that after reviewing the facts, the Department of Justice has decided not to prosecute the case. There are declinations with disgorgement, which are a relatively new phenomenon, and those are that the Department of Justice or the SEC will agree not to prosecute, but the company has to give up all of its ill-gotten gains. And then some have suggested that there might be a fifth type of thing, and that's a declination with disgorgement and forfeiture. And that means that not only do you give up all the profits that you've made, you also may have to undo the transaction and forfeit the actual corrupt entity. So let's take a look at the resolutions by years. And so this chart sets forth the enforcement actions that have been filed over the last 10 years, and it's broken up between the SEC and the DOJ. And some of those are duplicative because both the SEC and the DOJ have sought the enforcement action. And as you can see, 2016 was a pretty record year in the enforcement action. 2017, while it looks to be down, is, if you look at it on a year-over-year basis, if we can project out in the future, it shouldn't be as bad as it looks right now in comparison to the other years, and it might be historically significant as consistent with the past years. That issue arises because people, because most of the enforcement activity occurred in the first 3 weeks of the year before the inauguration of President Trump. And in the materials, I've set forth several of the six settlements that occurred on the last waning days of the Obama administration. There were 2 of them that I want to highlight here, and that's Zimmer Biomet, who was a 2-time offender, and then also on the second page, Orthofix was also a 2-time offender. And so those, in connection with those settlements, they agreed to extend their monitors for an transitional period of time. So then on the Trump side, there was a period of about 160 days of no action. And so people were beginning to wonder whether President Trump really meant what he said back in 2012 when he called the FCPA a horrible law, and that that enforcement had been absolutely crazy. And so during that period of 160 days, which was the second longest dry spell for enforcement activity, people were really beginning to wonder. But in the last 45 days, there's kind of been a flurry of activity, including the settlements that are listed here. So on June 16th, Linde, North America, filed a settlement action in which the Department of Justice declined to prosecute, and Linde agreed to disgorge $11.2 million worth of profits and other benefits. And that's the one that might be considered the disgorgement with forfeiture, because they had to also forfeit certain of their assets in the Russian territories that were the corrupt assets at issue. Another highlight that I want to mention is CDM Smith, which settled on June 21st. CDM Smith is a private company, and so that's kind of an interesting tidbit here, is that the FCPA does apply to both public and private companies in the United States. So it's not just the public companies that need to be concerned. And with respect to CDM Smith, that was a true declination with disgorgement, in which they agreed to give up $4 million worth of ill-gotten profits in India in connection with their settlement. Then I want to highlight something with Mr. Singh, who on July 27th was actually convicted of bribing two United Nations officials. That was the first time in 6 years in 5 attempts that the Department of Justice was actually able to obtain a conviction. The prior 4 trials that the Department of Justice brought under an FCPA violation ended up with a defense verdict. So that was an interesting tidbit that happened recently here. And then finally, with respect to Halliburton, that was another $29 million settlement that happened at the end of July, and Halliburton became another 2-time offender. So 2017 may be the year of the 2-time offenders. I don't know. Then, unfortunately, our animation kind of screwed up here, but you'll see the slide talking about the big penalties, and you'll see that these are the top 6 penalties. These don't include disgorgement or other sort of fines, and there's some big numbers on the board. Teva, for example, was done last year in 2016, right in December. And the Halliburton was the first settlement, not the second settlement up there. And then it's not on there, but in December also, Odebrecht settled for $3.4 billion of fines and penalties. That's a B billion. But there was a condition, and that was that they got to be able to pay. And unfortunately, in February or March, I think the government decided that they weren't able to pay, and so it ratcheted down the fines and penalties down to, I think, 500 million, which is still a big number in my opinion. So let's talk about, and again, I'm running through these quickly so that we can leave time for Joe and the panel up here. So one of the important cases that came out in June was a case called Koshis versus the SEC. That was a Supreme Court case that determined that disgorgement requires it has a 5-year statute of limitation, and that is important. Although it wasn't an FCPA case, that means that the disgorgement for the SEC has to be filed within a 5-year statute of limitations, and so that will be important for settlements going in the future. Also, in February, the DOJ issued a guidance document, although not unique not unique and illustrative. It does go through a list of 11 topics broken down by 46 questions, in which companies need to really review their compliance policies and make sure that they are compliant, because these are the questions that the Department of Justice is going to be asking the company to justify in respect to their policies. Similarly, around that same time, the OIG for the healthcare companies issued a similar policy back in January. It's not on the screen, sorry, talking about the same sort of guidance for their compliance policies. And so one interesting thing set forth in both of those policies is the companies are now going to have to justify, if there's an internal investigation, that they may need to make sure that their investigation was truly independent, objective, and appropriately conducted with properly documented. So then, on the international front, back in October, the International Standards Organization created the Anti-Bribery Management System, otherwise known as ISO 37001. And that, while it isn't groundbreaking and doesn't even have many of the best practices for some of the companies in the United States, it is a uniform system that is being developed across the world, and so companies are starting to get certified under it. And it created a headway when a couple of months ago, Microsoft and Walmart announced plans that they were actually going to seek certification. So I could see in the near future, companies are going to want to follow the bandwagon and get certified under ISO 37001. Also, it's important because some of the countries like Singapore and Peru are using that as a proxy for their own anti-bribery management systems. And then you'll see on there that France and Mexico recently updated their FCPA provisions. So what I want to do is I want to try to leave you with 4 takeaways and then one future thing that people need to be concerned about. So the 4 takeaways were that we need to enact a strong anti-bribery compliance policy, that companies need to make sure that they have appropriate oversight, training, and the resources, that they need to make sure that they audit those policies, and they routinely audit those policies to make sure that people are following them. And then they need to establish mechanisms to appropriately and quickly address violations once they occur and are discovered. And then with respect to the future, I think what we're going to see a lot more of in 2017 and 2018 is international cooperation. In 2017 or in 2016, the Odebrecht case was settled with the help of the Swiss and the Brazilian authorities. And as I mentioned before, that was $3.4 billion worth of fines and penalties as part of the settlement. And then the Rolls-Royce case that I mentioned earlier was a joint task force with the US, the UK, and Brazil. So with that, I'm going to hand it over to Joe up in Milwaukee, and he'll talk to us about whistleblowers.
Say, Ed, before you get too comfortable, we got our first question from the online folks, and let me just read it to you, and maybe you can either respond now or be prepared to respond a little later. The question is, would you mind restating the case that you mentioned that is not on the slide and therefore not written down for our audience?
Oh, Odebrecht, which is it's a Brazilian case, or it's a Brazilian engineering company, and it is, I believe it's spelled Oldebrecht. OR in the middle. Drew actually speaks Spanish and Portuguese, so I'll
I can read the face of people who do.
Yes, it's the Odebrecht case.
Okay. I'm Joe Masterson. As you heard in my introduction, my background is in securities and governance, so I have a lot of history thinking about bigger companies and SEC reporting companies. But I have just, in the couple minutes that we have to set up the panel discussion and the question and answer period, I want to make sure that everyone understands this is not, at least the whistleblower aspect of this is not limited to public companies in any sense. Anyone who can hear my voice, almost certainly, is subject to some whistleblower protection laws and to some whistleblower bounty laws. The world is a different place than it was just a decade ago. And we all need to take that into account in governing the enterprise that we care about, in investigating possibilities of misconduct, or at least the arguments of misconduct, and making appropriate disclosures about them, and then in dealing with whoever brought those things to our attention. So my key takeaways for introducing the rest of the discussion is that any enterprise can have either actual or alleged errors of things that they are either responsible to the government to do or have promised the world they will do, internal policies, and therefore there are at least arguments that they may have liability if they fail to do properly, or they at least are subject to real damage, public relations and other kinds of audience damages, if they are found not to have done them as intended. Second, again, I don't think I need to teach anybody about this, but we live in glass houses in a sense that we didn't 10 years ago. There is almost no enterprise that can be confident that it can maintain secret information over the long term. Audiences that care or have some incentive to look into things will be able to discover breaches or alleged breaches. And our enterprises need to be able to have investigated themselves, corrected matters as promptly as possible themselves, if there was indeed an issue, established that the allegation, though perhaps good faith, was in error, that the facts are different, and in any event, be able to respond appropriately to the bearer of the bad news, the person who asserted that you broke your promise, or you broke the law, or your report was wrong, or it's securities fraud, or somebody bribed a foreign official, or your books and records weren't accurate, or the basis for your incentive program to your executives was flawed, and they had enough influence and power to cause their own pockets to be padded at the expense of the shareholders, whoever that might be, or somebody else. There's just enormous pressures about those things, and whistleblowers get enormous protection. A significant number of the cases brought in the last couple of years by the SEC relate to whether whistleblowers were mistreated, which is illegal in any case that the SEC has jurisdiction over, or, well, maybe nobody in particular was mistreated, but your customary employment policies and your severance agreements somehow penalized or discouraged potential whistleblowers from telling the government the truth. And I will tell you that the SEC takes a very aggressive stand that that is illegal, that you must not penalize someone for reporting in good faith to a law enforcement agency or official about actual or alleged misconduct. So it is a tightrope that all of us need to walk, and that's not true only of public companies. That's true of private companies, and that's true of other kinds of institutions. I notice one person on our panel has a university kind of context. So it's going to be true there, I'm sure we will see. So those are the things that I think you need to know. You need to understand that there are huge bounties, cash rewards for people reporting things that ultimately lead to enforcement and collections. There are many, many whistleblower laws. 40 of the 50 states at least have whistleblower protection laws. that you need to worry about, as well as the SEC and OSHA and the IRS. So any company is going to have some kinds of reports where this can happen. There are niche law firms who make their living by saying, hey, potential whistleblowers, we can keep your identity secret. We can work with the government and know all the ins and outs of how to maximize your reward. And of course, we will take a percentage fee. And they do very well, thank you. So you need to understand that there are lots of incentives, and I think you should assume that there will be disclosure of actual or potential violations, that you have to be very careful in dealing with someone who either was or can position themselves to say they were a whistleblower, because any penalty, not just a discharge, but adverse employment action with respect to such a person, can be illegal. And their goal might be to make themselves fireproof by fitting within that box. So you need to be very careful and thoughtful about those. And you cannot penalize public reporting by those folks. You need to consider and decide if there's a problem or an alleged problem, whether you want to self-report it before anybody else does, and how you want to do that. Because a perception of an inaccuracy in your filings, in your disclosures if you're a public company or otherwise subject to that, a perception by your markets, even if you aren't a public company, that you were dishonest or inaccurate, can have very substantial consequences. And with that, I'm going to stop talking so our panel has time. But I'll be around when we can do more in the public question and answer session if you like.
Thanks, Joe. And before, I was remiss in not recognizing that, unfortunately, Patricia Pettit from Olympus is not physically present here, but she is on the phone. She had to remain down in Miami to attend to some business and could not get up to Indianapolis, unfortunately. But she is participating, so hopefully now with the panel discussion, she'll be able to chime in. So with that, again, we have an illustrious panel up here with very different backgrounds. And so I'm going to just throw it out there. First with Marcia, I guess, is sitting here today, what would you characterize as your #1 compliance priority for 2017/2018?
I think it's going to be the same priority from year to year, and that is, I used to think it was getting everybody trained, but trained is a strong word. I think they need to be aware, because they don't need to know all of the ins and outs of all of the statutes. There was a study years ago where I think it was Catholic University hired an attorney to find out how many statutes, regulations, circulars, bulletins applied in a higher ed institution, and it was well over 300. And so, and it's probably more now. And so that's just going to overwhelm them. But I always think, well, if they were deposed, what do I want them to know? That we have a compliance program, that there is an expectation of acting ethically, and that there's non-retaliation and a place you can call. Because anything more than that, especially at the beginning, is going to be too much. So as far as like the awareness and like, you know, and preparing for this, I'm like, okay, how do we look? Which made me a little bit more scared. It's like, you know, we have gateways now in China, India, in Europe. We have, you know, the number of students who study abroad in the last 10 years has gone up 62%. We go out of our way to try and recruit international students, and I see other higher ed institutions have been a little bit more aggressive in that. You know, export controls comes into mind. So are they going to know, because FCPA, export controls are very, very technical. So what is it that they're going to know? At least identify the red flags and then call somebody. So from a 2017 standpoint, it's, you know, moving sort of away from the you need to know all of these ins and outs, but being aware when something, where you're needing help, where you're going to need the assistance of the town council's office or the compliance office to navigate that. So if they allow us into the conversation while they're planning the event versus after something has happened, that makes, you know, timing is everything. So that's mainly it for us. Yeah.
Ann?
I agree with everything you're saying there, Marcia. I looked at this question a little more in the weeds, and our primary focus in 2017 is getting our arms around privacy data security. We are a chemical manufacturing company headquartered in the U.S. We have operations in China, India, Europe. We have personnel in more locations than that, and sales in even more locations than that. So I have kicked off the project that someone other than me, fortunately, is leading to assess the regulatory framework that applies to us, given that footprint. And he's leading a cross-functional team with HR and IT, will probably as well. They'll do that assessment and then a gap assessment, and then put a plan in place. And I suspect we'll need one by May 1st of next year. Have a privacy officer as well. Right.
From a topic standpoint, I 1,000% agree with you. That's the biggest area.
Drew?
Sure. I would say that at Cook, what we're looking to do is go beyond the communication and the training and to try to integrate and operationalize ethics and compliance to make sure that our business processes, our auditing functions, our monitoring and review, that all of those things are actually integrated into what we do in our everyday activities. Biggest thing go beyond having the program, having the elements, and having people know where to call. Go beyond that.
So we sometimes refer to that as compliance 2.0 because everybody's got compliant. You know, everybody should have a policy today. Hopefully, maybe you should. But now it's got to be a breathing, living document, and you got to really live it, not just have it and show it. It's a pretty little piece of paper.
Correct.
Patricia, are you on the line? I hope. Maybe.
The phone muted.
Can she unmute it?
I don't have control of that.
Okay. Well, exactly. As we get Patricia back on the line, unmuted, we'll move on to topic number 2. And that is training. And I know that Marcia mentioned that a little bit too. But how do you train new employees, or how do you roll out a new policy and then train the employees in terms of that? And Ian, you want to take a stab at that?
Sure. We are, at least from our perspective, a smaller company. We do not have a dedicated training function. And so one of the projects that we are working on is to have a more formalized across the company onboarding process. Some parts of our company do it really well, and some parts need a little help from outside. But we do have the concept, obviously, of new employees come in, and amongst the things that they're given in their welcome packet from HR is our code of conduct and sign off on that. And it's nice that it's one of a few things, so it's more important that way than getting on board and having to look through every policy and procedure. When we have new policies or procedures, what we do is we try to roll them out in touch points in a lot of different ways. We've developed a practice, not uniformly across the company, but developed a practice of a one-page, like 4-block, get the main things on one page. What is it? Who does it apply to? Where do you find it? Do's and don'ts, best practices, that kind of thing. We also recently started yammering within Vitalis. Yammer, I talked to Fernanda about that. I know other companies are doing it as well, which is the social media within the company, although I think it can be, external folks can have access to that as well. So we're reinforcing things through that, like, hey, did you see this? Another practice that the legal department has started, again, I can't take credit for this, someone else in my department who's very creative and smart, said let's do occasionally one-page legal memos that we email to everyone. And it's no more than one page. It's just a different version of that 4-block slide, right? And then we'll post them. We'll have a legal memo repository on our SharePoint page that everyone can see. And it's also the most recent. We did the inaugural one last Friday, so I emailed it to everyone last Friday. It got picked up in the front page of our intranet on Monday, and then I sent a little Yammer thing on Tuesday. So we're trying to kind of that whole thing of I don't know how many times you have to see or touch something for it to stick in your head, but that's kind of our evolving practice.
Drew, since you're a relatively new employee, how did you get trained?
Yeah, so maybe my disclosure to everybody is that I've only been a cook for a month, so I can't speak on behalf of the FBI because I'm retired, and I can't speak on behalf of the cook because I've only been there for a month. What I can say is that the onboarding process, there was an actual block of instruction on code of conduct and ethics issues and whistleblower and non-reporting, non-retaliation. I'd also add that at Cook, we have a director of training and education for ethics compliance functions specifically, and that we have online courses, we have in-person teaching, we have the top 10 cards and quick guides, we have a publication called The Ampersand that we contribute to and write on ethics topics. So we're trying to be multimodal and multi-channel the way we communicate over and over and over again. I thought it was 3 times. I heard it 7. Maybe for me it's 10 times that people have to hear things.
Marsha?
Well, since IU is so big, you can imagine all the layers. We have, for policies, we have policy advisory committee. So anyone who proposes a policy, it has to go through that. It identifies responsible office, scope, the reason behind it, the faculty have to review it, et cetera. But as far as training, we have an orientation where we just introduce the compliance program, non-retaliation, who you can contact. Because I'd learned from a colleague, I think they were from Michigan, that it's exactly what you said. You have to sort of, it's a process, and you have to repeat sort of the key things. But at the very beginning, when they're just shiny and new, don't get into too much of the details. But, you know, like for export controls, we have 2 slides that say, here's the law. If you do business with any of these countries, call somebody. So it's very, very high level for those technical things. So that's orientation. We do have an orientation for the health sciences, medicine, dentistry, optometry, nursing, and the other health sciences because they're regulated so very differently. So there's that. But in addition to that, we have a lot of subject matter experts from an OSHA standpoint, international immigration, et cetera, where it's very subject matter specific. You can either request an in-person, an online one, or whatever. I go out of my way to find out when they're having like executive committee meetings, faculty staff meetings, and sort of embed myself there because that's when you're finding out if they are putting together this program that happens to involve another country.
And what's great is when they invite you, you don't even have to find out. And when they invite you,
yeah.
Say, please come and present on whatever you think we need to know.
Or they ask a question that starts off with, what if? Yeah, exactly. Another department called me, and so that's helpful. Just to, you know, I tell them we'll wrap training around whatever they need. And if we use hypotheticals that are specific to them, then that helps, so to the extent that we can customize it, we can, but now we're starting, the online and the animated stuff is what we're moving to. Otherwise, they shut down in about a half an hour.
Infographics are another thing.
Yeah, they love graphics.
Yeah, the last book I read, I thought, could this just be an infographic? A lot of reading to get to a simple point.
And I think Patricia's now joined us. Patricia?
Can you hear me?
Are you on?
Can you hear me?
Perfect, yes, thank you.
Oh, great.
Yeah.
So here I am.
Well, thank you very much. And so I guess we'll go back to the first question. What is Olympus's or your number 1 compliance priority for 2017 or 2018?
Well, I think number 1 priority is continue to enforce our compliance program, in place, and continue to enforce that and strengthen it year after year. I think it's part of our goal. I think being, you know, more into the weeds, that our biggest goal, or my personal biggest job this year is just making sure that we get even closer to our third-party distributors, anybody that operates in an international market, you know, if I was in America, is a top concern. So strengthening our monitoring activities, strengthening our auditing capabilities for these third parties, keeping close contact is very much number one priority. And I think, and training them. So going to the second question that you had, right? Training goes along with everything that we do. We actually have an annual training plan that is developed year after year that contemplates what are the main activities that we're going to do through the year. And we do a mix of live training and web-based training. So we do have a new hire training, and then we have our training throughout the year. We try to divide it and split it. We have, April and October are our busiest months when we have more of those training segments going on to the employees. So we try to split it throughout the year so it doesn't get, too much. At the same time, we do enforce them. They are, if you don't take them on time, you do have compensation. It impacts your compensation. So we're very serious about that. And we actually provide training for our third parties too. That's, part of our big Latin America project. So all those training sections to our third party distributors, for example, they're all live. So they might not be in person, but they're all, through a live web-based application.
And you mentioned third parties a couple of times, and I think that we kind of glossed over that on up here. And so, and how do you deal with third parties in training?
We've identified, we've kind of looked at where are the bigger risks and determined that it is worth face-to-face training that usually I conduct with our channel partners, distributors and agents in India and China. And I've done that a few times. I've had a few scary questions from them, but they've been very open to it and really have, absorbed it and many more questions sometimes than live training sessions within the company. So that's a really interesting experience. And it was the first time I did it, 8 years ago, I think, the first time I did it. I was thinking, well, maybe I should just train the agents because I don't really want to take responsibility for the distributors. And then I realized, well, I'm not taking responsibility. What I'm doing is communicating our expectations. We had a lot of good dialogue out of it and a lot of opportunities for improving things that our commercial team who sat in on it too, the local commercial team, and I developed as a result of some of the comments and questions.
Great. Drew?
I would just say that we're going beyond the specific policies and brochures and things that we can do to help them understand what our code of conduct and what our expectations are, to including those things in our agreements, but also looking to do more in-person training throughout the globe.
We, unfortunately, many of the folks that we contract with have very similar training programs, or in our contracts with the government, it requires the other party to have these programs in place. We do have like research or education services agreements where they're out there in the field, and we put together a training package and say, you're going to train them when you get there, right? And so it varies greatly with regard to that, but the follow-up is, we're not sure how much of that is getting done, so that's part of the challenge.
So I guess the next topic might be investigations. And so I'll throw it out to Drew. Does Cook have or the compliance group have a separate investigations arm? Or?
Well, we didn't. Now I'm there. So one of the things I'll be doing is we're looking to basically have a process to reassess what our process is for the intake of all complaints. Because when you say an incident or investigation, those things are very, very wide-ranging. Everything from minor, really H&R kind of issues up to full-blown investigations that require outside counsel and dealing with investigative authorities from multiple countries. So we're trying to have a process in place by which we can triage those things, get them referred to the correct place, and after they're referred, making sure that we monitor those investigations to ensure that they're thorough, that they're documented, and they're doing all the things they're supposed to be doing.
Patricia, does Olympus have a separate investigation team?
Yes. We do. We have a separate investigations team that, is responsible for investigations. There's members of HR, there are members of legal, there are members of compliance people in there that, do a triage to see if this is an HR issue, if it's a compliance issue, if it's a legal matter. And if it is a compliance issue, it is investigated by a central team.
Marsha?
We do, as far as our hotline goes into, it's managed by internal audit, but once they receive it, it's categorized. Or if one of our offices receives a complaint, it's categorized and it goes to general counsel's office is notified, compliance, internal audit, and let's say it involves environmental health and safety, they're notified. And then they coordinate the investigation from there and then report back so that there's documentation that has been handled. However, there's going to be some informal complaints that are handled within the department that we may never know about. As far as breaches, we have an incident response team because the university gets hacked all the time. And anything that deals with sort of healthcare or research related, there's a QA process that's involved there. So we go from, very informal to very, structured depending on the type of complaint.
Yeah.
I note your point, Marsha, about things you may not know about.
Right.
And I think that's the biggest challenge with regard to investigations. To the initial question, we do not at Portellus have a separate investigation team. We don't even have a separate compliance function. I'm general counsel and compliance officer. Know all the risks associated with that are in the company size and the risk profile that we're not alone in that regard. I'd love to only have one of those jobs. I think that's my goal someday to only have one of those jobs. And so I also don't have having no compliance staff and having a very lean legal staff. I don't have dedicated investigators. I just use who is appropriate. I'm in essence the triage point to the extent it comes in through the hotline or someone else otherwise reports it to me. And the vast majority are HR related, so HR manages it, and I'm just really I'm in the informed category there. Very often not even a decision maker. Oftentimes nothing comes up that even needs me to kind of weigh in on. But anything else, I'll go from investigating it myself. I did love Nancy Drew as a child. To having someone else in the legal staff or HR or finance, just other folks who are good at this. I don't have an investigation playbook. That's another thing I'd like. It's not a priority, but it's another thing I'd like to have is something that I could make a little more replicable and maybe expand out. But my biggest issue is getting folks to know when you should report something up. And I've developed a specific training for code of business conduct training for supervisors to try to how to otherwise hit them over the head. When you get this report, it's not your job to figure it out and then maybe tell me about it. It's your job to tell me about it. And then we'll let you know if you have anything else to do in this regard. Go do your day job. Don't worry about this. And that's a challenge. And I sure welcome any insights that anyone has on that. Getting people, I think my company, we have highly ethical folks who want to do the right thing. They understand we have to have a code of conduct. They just don't always make the connection that it's what their role is in that and what the compliance role is.
They're helpful.
They're very helpful. Very energetic and very helpful.
And so I think in the essence of time, we'll have one last question, and that is we heard the whistleblower update. Does everybody have a formal documented policy regarding whistleblowers? Drew?
Yes, we do. And the one thing I would say about it is that unlike what I was used to at DOJ, where we had a whistleblower policy and that was it was communicated in whole, there is the way Cook goes about communicating whistleblower. It goes from the very, very basic. At every time clock, it says, if you see a problem, report it, and you will be taken care of. Essentially, it's very, very simple one-liner to our online process where it explains a little more what it means, and then our full policy. So you can access it at a very simple stage all the way up to more in-depth policies. So that was interesting.
Marsha.
as a state institution, we're also considered a state agency in many regards. So not only do we have a policy, but it's also state law for non-retaliation. So I make sure they know that. And I tell them, don't wait till it's a complaint, you know, or an issue. You can just call and share your concerns. You never have to, you don't have to share your name. So ever since we've pushed out the, you know, here's the hotline or, you know, some way to reach out to us, the number of calls have increased, which is a good thing because now a lot of times you find out about things sooner rather than later, and a lot of them are sort of HR, but that's
Patricia?
Yeah, the way we go about it is similar to what my colleagues have said. We just advertise our communication channels. We have a no retaliation policy. We like to get close to the team and be very frank and open and know that we have our open doors for them to come in and talk to us. Basically, that's how we go about it.
And I guess one related question, given the Latin American focus, is there a cultural issue associated with whistleblowing or anything in your experience?
No, I mean, they do approach us, I think, in a similar way. I think they're sometimes even more open. I think in Latin America, the lines of what is legal, what is compliance, what is HR, in my experience, are not so well defined sometimes. So you end up hearing they have a very broad definition of compliance, and you end up having a lot of folks reach out to you about various subjects. But we try to get, you know, people that speak the local language close to them to make sure that they feel comfortable and that we have an easy way of accessing the compliance team, no matter where you are.
Sure. Lillian?
Similar to what everyone else has said, we have non-retaliation at the beginning and at the end of our code of conduct, at the beginning and the end of our posters about it, at the beginning and the end of our training on it, and then specific whistleblower and open door responsibility training is part of that code of business conduct for supervisors training that I do, making sure they understand their requirements to have an open door and what they do when they, and then again, definitely non-retaliation. And using real life examples, like, yeah, just because you're not doing it, you see it and your supervisor step in or report up on it.
So I think we have about 5 more minutes. Are there any questions either from the audience or online?
Right, you can speak right here. There, you can speak right here. Oh, now you tell me. Yes, my name is Robert Blue from Phoenix, Arizona, and my question is on the ISO 37001. I notice on your handout here, Walmart and Microsoft, they're trying to seek certification. So the smaller companies, are any of them trying to do that? And is there a training program or something for companies that are seeking to do that? And if so, how does one get certified? And if it's really needed?
Well, that's a really loaded question, and a lot of moving parts associated with that. Yes, there are smaller companies that are trying to get certified. Is it worth it? That's the the $3.4 billion question. If you're all the rest, as some commentators have suggested, there isn't anything, some of the best practices in the United States aren't necessarily included as required as part of ISO 37001. And so is it really, best practice and evolving to your compliance plan? I don't know. But is it going to offer you protection? No, in the United States, it's not a get out of jail card free. It is just like every other ISO policy. It's a process and a procedure, and it's a documentation that, you know, it's like your quality standard. You're going to follow it, but every once in a while you're going to make a mistake, and that doesn't relieve you of the mistake that you made. And so, you know, Drew's shaking his head over there. You know, do you have any thoughts on it?
I mean, it's something that we're considering, obviously, but you wonder, even though it's a global standard and it will be recognized by other countries, what's the true value in it? Is it something you want to make sure you're hitting all those elements, but maybe you want to go beyond that?
Well, and to your one point, yes, there are lots of consultants out there that will charge you a lot of money to work you through the process of getting certified. And, you know, I mean, you can just Google ISO 37001 and get inundated with it. So, any other questions? Hearing none, thank you very much for your attention, and look forward to seeing all of you again, I think September 13th for the next BLT.